Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be talking about no-fault arbitration through the American Bar Association. And with us we have James Skelton, who's the Vice President of New York State Insurance Programs, and also Janet Miranda, who's the Assistant Vice President of New York State Insurance Case Management Center at the American Arbitration Association. James and Janet, welcome to Law You Should Know.
Hi, thank you for having us.
Okay. James, to start us off, just tell us about the no-fault arbitration program in New York that's administered by the American Arbitration Association.
Sure, Ken. No fault has been around since the mid-'70s, and what no fault is a way for injured parties to collect compensation for health care provided as a result of automobile accidents. In New York, automobile drivers are required to carry what's called a no-fault insurance policy. So when a person is injured, they can submit their bills to arbitration so that the health care portion of the claim is resolved quickly so that injured parties can continue to receive health care, whether it's chiropractic, acupuncture, or something else. Traditionally, before the mid-'70s, when no-fault was enacted, injured parties would have to file lawsuits in court and sometimes wait 4 or 5 years before they could collect. During that time period, the doctors would stop treating the patients because they weren't being paid, and the legislature enacted the no-fault law, which the primary focus was the speedy resolution of claims. So today, doctors and other healthcare providers will submit their claims for no fault to the American Arbitration Association, and we will administer those claims. We will attempt to settle the claims through a process called conciliation, and if that's not successful, the claims will be escalated to arbitration, where they'll be heard by an arbitrator. So that, in a nutshell, is no fault.
And I just want to mention also that the no fault, as the name suggests, is that medical claims are paid usually regardless of fault. There are some exceptions, and sometimes they're voluntarily and quickly paid, but sometimes there's a dispute about the medical bill and whether all the procedures were followed, and then you need an intermediary to resolve the dispute, and that's why we have the American Arbitration Association. Now,
correct.
Some people
we were assigned.
Go ahead.
Sorry, Ken. No, we were selected as the administrator by the Department of Financial Services, which used to be known as the New York State Department of Insurance. So, yeah, we were assigned as the administrator for the program, and we've been handling the program since the mid-'70s.
And you handle thousands of cases every year as part of the program.
Yes, we've been, when we first started, we were handling several thousand cases a year, and in the past several years, the volume has exploded. Last year, we handled about 304,000 cases. This year, we're on target to handle approximately 340,000 cases.
Now,
and I just want to add...
Yes, go ahead.
I'm sorry. I just want to add that a victim can also be a driver, a pedestrian, a passenger, or a bicyclist.
Arising out of an auto accident.
Yes.
With the car somehow involved. And everyone has it as part of the insurance, and for a bicycle or a pedestrian is probably on the car that was involved in the accident that injured them. Now, a litigant, their attorney, or the medical provider may have the option of going to court and going through the legal system which may be subject to delays or backlogs. But tell us, once it goes into arbitration, if you're not successful at working on an agreement between the parties, tell us about the arbitration process through AAA.
Well, Ken, when the case is filed, we go through a very rigorous examination of the documents that have been submitted. We break down the file into the various components, which would include bills, medical reports, investigation, the denial by the insurance company, and we break down the case so that it's easy for the arbitrator to understand and for us to get a better handle on the issues. We also wait until the insurance company submits its case to make sure that we understand that the defenses that are being asserted, so that we can speak to the parties in an attempt to settle it. So the first few months of the case is the AAA staff analyzing the file, making sure that the proper documentation is there, and attempting to settle with the parties. We have had a good percentage of cases, sometimes 40 to 50% of the cases filed have been settled through what's called conciliation. If the cases are not settled in conciliation, we have a process where the cases are then escalated to arbitration. And what that means is the cases will be put into scheduling and scheduled for a hearing in the venue where the treatment occurred, usually within 100 miles from where the treatment was rendered. The case will then be assigned to an arbitrator who will analyze the file, bring the parties in, hear the arguments, and issue a written decision within 30 days of the closing of the hearing. That, in a nutshell, is the no-fault process from AAA's perspective.
And how long does it take from the day you decide conciliation is not going to work until that no-fault hearing is held by the arbitrator? Approximately.
We've been analyzing that. Yeah, we've been analyzing that data, and we try to keep track of that because as the volume increases, we monitor the number of arbitrators on the panel. We look at how the conciliators are doing. We look for trends with the parties. So we do monitor those numbers, and one of those numbers is from the date of the case is escalated up to the date of resolution, and we're looking at anywhere from 12 to 14 months on average, from filing to resolution.
And what
if I could just add, I'm sorry, if I could just add, for the cases that are resolved, that's almost 1 out of every 2 cases, because we have between a 40 and a 50% settlement rate. Those cases are generally settled between 45 to 90 days from filing. So that's a really speedy resolution in conciliation.
And what are some of the common issues that are raised by the claimants or defenses that are raised by the carriers that bring the cases into arbitration in the first place?
Well, I would say the most common issue in arbitration is medical necessity. These cases are where an injured party may receive medical treatment, including chiropractic care, acupuncture, different types of testing, and the insurance company will contest that the treatment was medically necessary, and they will submit their proof, which will usually include a peer review or an independent medical examination, and they will contest that the treatment was medically necessary. This is the vast majority of the cases that we see in arbitration. There are also cases that will involve whether it's a conflict of law question, if the medical provider alleges that there was fraud or something else. There could be a policy violation, a failure to appear. Sometimes an injured party will be requested to appear at a what's called an examination under oath, which is a process where the attorney for the insurance company will ask the injured party questions about the accident and the treatment that was rendered. If the injured party doesn't appear, then the insurance company will argue that this is a policy violation and they shouldn't have to pay. There are other cases that will be denied because the insurance company claims that the injured party failed to provide necessary documentation. So those are a lot of the major issues that we see in arbitration.
And I just want to add, go ahead, Janet.
I'm sorry. This is Jen. I agree with Jay. There's also the issue of fee schedule, whether it's calculation or just interpretation of the fee schedule.
So there is a fee schedule, and it might be modeled after the workers' comp fee schedule, but under no fault, a doctor can only charge or receive a certain fee if the insurance company feels it's covered.
Correct, and that's downstate in Long Island, Manhattan. We're in Region 4 of the state of New York, and different procedures will be fee scheduled at a different amount. So if a case was submitted, if a claim was submitted to a different healthcare provider, they might be paid, $70. Where in New York, if a claim is submitted under no faults, we use the New York workers' compensation fee schedule, and those fees are calculated according to the New York State workers' compensation fee schedule. So it may or may not be a different amount, but that's the fee schedule that we use when calculating the proper fee schedule for any of the services rendered pursuant to no fault.
And you mentioned earlier about a claimant, an injured person, receiving a letter asking them to come to an examination under oath. A person should not ignore that letter. If they have an attorney, they should bring it to the attention of their attorney. If they don't have an attorney, they may have the right, and they might be advised to get an attorney for that proceeding. But it's not something they should ignore because it could lead to denial of their medical claim.
Sure. I mean, we're not we're not in the position to give legal advice, but certainly there are many good no-fault practitioners in the state of New York who would be able to explain their rights and obligations. And certainly, no-fault. When I started, actually, I was a no-fault arbitrator for many years, for 14 years. And when I started, there wasn't the body of case law that there is now. Right now, the case law, whether it's in court or in arbitration, is exploding. The number of cases filed is at an all-time high. Issues are being litigated to the Court of Appeals on a daily basis. So we follow this growing body of case law, and this is becoming very complicated. And certainly we advise, if people call us for advice, we refer them to the New York State Bar Association for a referral. But certainly there are many good no-fault practitioners that would be in a position to give them good legal advice.
And a person may already have an attorney working on their negligence case, so they should bring it to the attention of that attorney and, again, not ignore it. We're going to take a short break now. When we return, we'll continue our discussion with James Skelton and Janet Miranda of the American Arbitration Association about their no-fault arbitration procedures. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at nccradio.org. We'll be back in a moment.
This program is brought to you by Nassau Community College, which offers a paralegal studies program. Students can major in paralegal studies while earning their associate's degree, or earn a paralegal certificate if they already have a college degree. These programs can even help you start a second career as a paralegal. It's a program for anyone who wants to work in a law office assisting lawyers, the government, or a position in an insurance company. More information about full-time, part-time, days, evenings, weekends, or online courses is available by calling 516-572-7774 or by email at paralegal@ncc.edu.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking about no-fault arbitration through the American Arbitration Association. The procedure set up for resolving no-fault disputes for payments after accidents handled by the American Arbitration Association. Our guests are James Skelton, who's the Vice President of the New York State Insurance Programs, and Janet Miranda, who's the Assistant Vice President of New York State Insurance Case Management Center. Assuming that the case is going to be resolved through your arbitration panel, how is that? The arbitrator is totally neutral. How are they going to decide how are they going to decide who's to decide in favor of? The injured claimant, the insurance company, the vendor. How do they make that decision?
Well, the no-fault arbitrators are assigned to the cases, and they have access to our electronic case folder where they do review the files that are submitted. And as I said in the beginning, we submit when the parties submit their documents, they're uploaded into the electronic case folder. So the arbitrators review the files before the hearing so that they're familiar with the issues that will be presented to them at the hearing. And thereafter, the parties do come in. The parties are scheduled for 15-minute hearings, and they come in and present their cases. The arbitrators, again, because they're familiar with the files, will be able to ask specific questions about the treatments and about the defenses asserted, whether or not any documents rebut the assertions of the other side, so that the discussions are very, very focused. The parties are very well prepared. They come in. The arbitrators, review the case law. They have a very rigorous, analysis. What I should say, that they conduct a very rigorous analysis of all the proof, and they ask very pointed questions of the attorneys appearing before them. So it's a very focused process. The parties are always well prepared, and traditionally the hearings run very smoothly. And by the regulation, the decisions are due within 30 days of the hearing's completion.
And sometimes the parties will testify. The injured persons. Sometimes the injured persons, the person who's seeking the benefit, will give testimony before the arbitrator.
Oh, yeah, we have testimony in many cases. Sometimes it's the injured party will come in, and the injured party could be coming in for a number of reasons. It could be because they have a lost earnings claim, or it could be because they want to testify in a specific issue, whether it was a cancellation notice or whether or not they received a letter for an examination under oath or something like that. Also, we have many cases where the medical providers will come in and testify, whether it's a treating physician, chiropractor, whether it's a radiologist who's testifying based on the findings of an MRI or something else. So, yes, we have testimony in many, many cases.
And Janet, I just want to take a minute here. Can you just give us the background and tell us about the history of the American Arbitration Association?
Sure, I can give you a little bit of information, and I'll give you our website as well, where they can get a whole lot of information just because of time restraints. So the American Arbitration Association is a not-for-profit organization. We are, the largest private global provider of alternative dispute resolution services in the world. AAA was founded back in 1926. Following the enactment of the Federal Arbitration Act. And, we always had a specific goal of helping to implement an arbitration as an out-of-court solution for resolving disputes. I know that in the very beginning, they began with single cases, like from the Actors Equity Association, and now we're doing cases, between International Center for Dispute Resolution through, cases in commercial, construction, consumer, elections, employment, environmental, government, labor, real estate, contracts. So, yeah, you guys can get a lot of information about the American Arbitration Association at www.adr.org.
And I also wanted to ask the two of you, are there opportunities for attorneys to become part of your no-fault arbitration panel?
Certainly. If any attorney is interested in becoming a no-fault arbitrator, they can certainly send their resume to me. And what we do is we keep all of the resumes on file. And if the Department of Financial Services wants to set up interviews for new arbitrator positions, we send them all of the resumes that have been received. And then they discuss it with the screening committee, and the screening committee and the Department of Financial Services will ask us to set up interviews for certain candidates and then conduct interviews. So if anybody's interested in becoming a no-fault arbitrator, please feel free to send a resume to me, Skelton, Skelton, the letter J, at adr.org.
I just want to add, if I may,
Sure.
Also, in accordance with the First Amendment of Regulation 68D, there's a subdivision there that talks about the qualifications of arbitrators that they could find there. Qualifications include the attorney should have some no-fault experience for at least 5 years.
And attorneys do not have, might be just part of their practice, but they would not be participating in other no-fault or tort cases, or this would be a full-time job for them?
Well, arbitrators are appointed by the Department of Financial Services, and they're independent contractors, so they're not employed by the AAA and they're not employed by the DFS. So this is appointed pursuant to the regulation. So if they have any information, if they have any questions, they can feel free to contact me. I can refer them to the regulations where it outlines all of the job, the description of the position, how they're appointed by the Department of Financial Services with the screening committee, and that they serve at the pleasure of the department.
And do you have attorneys who are on panels for other types of cases, especially in the negligence field, for UM cases, for SUM cases, for coverage disputes, or anything else along those lines? That you just call on that attorney when necessary?
Yeah, we have separate panels for SUM and UM, and those the panels do not overlap. The SUM arbitration cases are a different panel, and they're also appointed by the Department of Financial Services.
But again, then it's a much less involvement. They're just doing an occasional case, or they're an independent contractor doing and have a lot of cases on their docket.
Well, I don't know what's considered a lot of cases. I know that the attorneys that are appointed to the SUM panel also go through a process with the Department of Financial Services, that they are assigned to cases, that they do conduct their hearings, but their hearings are a little more involved, and they have different issues than they do in the no-fault cases. So their hearings are not the 15-minute blocks that we schedule in no-fault. They're usually longer hearings and most involve testimony.
And how can an attorney find out more about becoming part of an SUM or a UM panel?
Again, if they'd like to send it to me, and I can forward it to the correct persons internally at AAA, and I'm sure that we'd be happy to get somebody to get information to them.
And just give us your contact information one more time.
Sure. Skelton, J, Skelton, the letter J, at adr.org.
Just going back to no fault for a moment, if one party is not happy with the decision made by the arbitrator, are there avenues of appeal to a court, to a master arbitrator, or any other venue?
Sure. That's a great question, Ken. Not that all your questions aren't great, but this is a particularly good one. In no fault, we have a process where if a party is not happy with the arbitration decision, then they can appeal to a master arbitrator, and the master arbitrator will review the case to make sure. And there are certain guys. It's not a de novo review. They're not going to revisit the decision. They're not going to, go through the case in the depth that the no-fault arbitrator has gone through, because it's not a de novo review, and they'll either affirm or remand the case back for further proceedings. And if the aggrieved party is not happy, then they can go to court pursuant to Article 75. So there's a several-step process that they can pursue if a party's not happy with the arbitration decision.
And do you also accept applications for a panel of master arbitrators?
Yes, again, these are also appointments by the Department of Financial Services, and again, the volume of no-fault cases is great. I mean, as we said before, the no-fault cases, we're on track for 330 or 340,000 cases in that area, but a small percentage get filed from master arbitration, so that's a smaller number. And again, the cases will be referred to master arbitrators on a case-by-case basis as they come in.
Okay, we only have a moment left in the program, but if an attorney or a claimant is deciding whether to go into court to resolve the no-fault dispute or to submit it to the American Arbitration Association, why is the American Arbitration a better deal for them?
Well, Ken, we've been administering this program since the mid '70s. We handle no fault, and in our division only no fault. We have the filing fee for cases in no fault is $40. The cases are handled by professionals here at AAA. We administer the program very efficiently. We work with a great panel, and we have great success we monitor the cases. We try to make sure that there's a speedy resolution of all the cases that are filed here, and we take great pride in doing our job well. Not that the courts don't, but I think the courts have traditionally been overwhelmed by the volume of no-fault cases, and I think we put a lot of resources to making sure that there's a speedy resolution of these claims, and I think that the people who file in our forum get a good bang for their buck.
And a case is not going to be dismissed because of some type of motion or procedural motion or other motion. Everyone will has the right to have their case heard by a no-fault arbitrator.
Yeah, that's another difference between court and arbitration. In arbitration, there is no motion practice. There's in court there's motion practice. There's discovery. In arbitration, we try to get to the merits of the case. We try to do it in an expeditious manner, so that the parties can. Again, it's about that the whole process, the whole thought behind no fault was the speedy resolution of claims, and that's what we're focused on. So
okay, I wish we had some more time, but I would like to thank our guests, James Skelton and Janet Miranda from the American Arbitration Association, and you can just Google American Arbitration for more information. You're listening to Law You Should Know. If you missed any part of this program or want to tell someone else about it, the podcast is available at nccradio.org. And please tune in on 90.3 WHPC next week for another program on Law You Should Know.